Hello everyone and welcome to Law Books Simplified. I am Advocate S.R. Paul from Calcutta High Court, and in this segment we will do the thorough study of the Code of Civil Procedure by C.K. Takwani. And in this segment we'll go to every paragraph, every lines of every pages of this book thoroughly, and I'll try to explain so that it makes a little easier for you guys to understand this. So without any further delay, let's start. So let's start with procedural law, and it says laws can be divided into two groups. First, substantive law, and second, adjective or procedural law. Whereas substantive law determines rights and liabilities of parties, adjective or procedural law prescribes the practice, procedure and machinery for the enforcement of those rights and liabilities. In Halsbury's Laws of England, it has been stated that there is at the outset of a vital and essential distinction between substantive law and procedural law. The function of substantive law is to define, create or confer substantive legal rights or legal status, or to impose and define the nature and extent of legal duties. The function of procedural law is to provide the machinery or the manner in which the legal rights or the status and legal duties may be enforced or recognized by court of law or other recognized or properly constituted tribunal. So it's simply stated here that laws are of two types, substantive and adjective. So what is substantive law? The type of law which gives you the right, which confers you some legal right, of which under which you can seek remedy. If those rights gets violated, you can seek remedy. We'll come to the examples later, but let me tell you, IPC is one of the substantive law, and CPC, which we are reading here, is one of the procedural laws. Let's go further. Procedural laws prescribe procedure for the enforcement of rights and liabilities. The efficacy of substantive law to a large extent depends upon the quality of procedural laws. Unless the procedure is simple, expeditious and inexpensive, substantive laws, however good, are bound to fail in achieving their object and reaching the goal. So it says that if the adjective law, if the procedural law is expensive, if it is not that simple, if people are finding hard to go through the procedure to the machinery under which they can get or seek remedy, that is very hard, then people will not get the justice. Then the actual value of those substantive laws will not be justified. That's what is written there. So let's move forward. Procedural law is thus an adjunct or an accessory or to substantive law. Two branches are complementary to each other and interdependent, and the interplay between them often conceals what is substantive law and what is procedural law. It is procedural law which puts life into substantive law by providing a remedy and implements the well-known maxim ubi jus ibi remedium. So in this paragraph we get to know that these two branches of laws are interdependent, and how that is because substantive law gives you the right, but how to enforce those rights? Procedural law or adjective law says you that. So it is based on the maxim ubi jus ibi remedium, which we will discuss later, and it is a very important maxim, let me tell you. Indian Contract Act, the Transfer of Property Act, the Industrial Disputes Act, the Indian Penal Code are instances of substantive law.
So let's move to the history of the code.
While
So before
the
1859,
Indian
there
Evidence
was
Act,
no
the
uniform code
Limitation
of civil
Act, the
procedure.
Code of Civil Procedure,
There were
the Code
different
of
systems
Criminal
of civil procedure
are
in different parts of the country.
procedural law.
The first uniform code of
The
civil
Code of
procedure
Civil
was
Procedure
enacted in
is an
1859,
adjective or procedural
but
law.
that code was not made applicable to
It
the Supreme
neither
Courts
creates
in the
nor
Presidency
takes
towns
away any right.
and to the Presidency
It is
small
intended
cause courts.
to regulate the
Some
procedure
amendments were
to be
made
followed
therein,
by
and the
civil
code
courts.
was applied to the whole of British India actually, but there were many defects in it, and therefore a new code was enacted in 1877. Again, another code was enacted in 1882, which was also amended from time to time. So nothing to understand here. In 1908, the present Code of Civil Procedure was enacted. It was amended by two important amendments, Acts of 1951 and 1956. On the whole, this code worked satisfactorily, though there were some defects in it. The Law Commission in its various reports made many recommendations, and after carefully considering them, government decided to bring forward the Bill of Amendment of the Code of Civil Procedure in 1908. Keeping this in view, inter alia, the following considerations. So the consideration number 1 is a litigant should get fair trial in accordance with the accepted principles of natural justice. Every effort should be made expedite to the disposal of civil suits and proceedings so that justice may not be delayed. Number 3, the procedure should not be complicated and should to the utmost extent possible ensure a fair deal to the proper sections of the community who do not have the means to engage a pleader to defend their cases. So in the first principle of which was amended in 1908 Amendment Act was the litigant must get a fair trial, and which is very much expected that every litigant should have the accordance in their trial of the principles of natural justice. And the second one is it should be made for the disposal of civil suits, and the third one is the procedure should not be complicated, it should be simplified, and this procedure should be followed by everyone so that the essence of substantive law should be kept. That if this procedural law is it's that much complicated that one litigant would not have that urge to exercise his substantive rights, his legal rights through those substantive laws, so the whole agenda of this act will fail. So it is very important that the procedure should be made very simple and not complicated. So moving on, some of the important changes made by the Amendment Act in 1976 as are under. Number 1, the doctrine of res judicata is being made for more effective. So we will go about res judicata later on this book. Number 2, power to transfer proceedings from High Court to another is given to the Supreme Court. Number 3, freedom from attachment of a portion of salary to all salaried employees is guaranteed. Number 4, provision of giving notice under Section 80 before the institution for a suit against the government or a public officer is made less stringent. Number 5, restrictions are imposed on the rights of appeal and revisions. Number 6, provisions are being made to ensure that written statements and documents were filed without delay. Number 7, new order 32A has been inserted to provide a special procedure in litigation concerning the affairs of a family. Number 8, the practice to pass preliminary and final decree in certain suits is abolished. Number 9, scope of summary trials is substantially widened. Number 10, important changes may have been made to provide relief to poorer sections of the community. So we will go through every one of these important changes later on this book. So let's just have them for reminded right now. The amendments made in 1976 were not found sufficient. With a view to dispose of civil cases expeditiously, Justice Malimat Committee was appointed by the government. In pursuance of the recommendations of the committee, the code was amended by the Amendment Acts of 1999 and of 2002. Important amendments made by the Act of 1999 and 2002 may be summarized thus: in several matters such as issuing of summons, filing of written statements, amendments of pleadings, production of documents, examination of witnesses, pronouncement of judgments, preparation of decree, etc., a time limit is prescribed. Number 2. A new provision for settlement of disputes outside the court has been introduced. Number 3. A number of adjournments have been restricted. Number 4. A provision for recording of evidence by the court commissioner has been made. Number 5. Endless arguments are sought to be shortened by 1. Empowering the court to fix a time limit for oral arguments, and number 2. By permitting written arguments to be placed on the record by the parties. Number 6. A provision is made for filing of appeal in the court which passed the decree. Number 7. Instituting of appeal against the judgment is allowed where the decree is not drawn up. Number 8. Scope of first appeal, second appeal, later patent appeal and revisions has been curtailed.
So that's it for now, and from next video we'll start from commencement. And do subscribe, and thank you. Have a nice day.